Welcome to May McKinney Podcast.
Welcome to the May McKinney Podcast with the attorneys of May McKinney, PLLC, Nashville criminal defense attorneys Rob McKinney, Shyanne Riddle, and Savannah Edmonds work together to defend clients facing some of the most stressful and high-stakes moments of their lives, combining trial experience, strategic defense, and a deeply human approach to representation. I'm Leann Lyon, and today we are talking about how a collaborative defense team can change the way criminal cases are prepared for, communicated, and best of all, resolved. Hello, everyone.
Hey, Leann, how are you?
Great to see you again. So how does a team-based approach change the way criminal defense cases get prepared for compared to having just one attorney handling everything alone?
I'm a little bit older than Shyanne, and I started out in a firm, but I was the only one to do criminal defense. And sometimes when you're a lone wolf or by yourself, you have a tunnel vision that you have the right way to try the case, and you have this tunnel vision, and you go the way down this path that you don't. With the collaborative approach that we started here when we joined forces together years ago, we started bouncing ideas off each other. We bounce ideas off our paralegals, off our receptionists, off our team manager, off each other. And we find that having more than one point of view toward any case and have a multitude of views serves our clients immensely.
Yeah, I think that it is both beautiful and challenging at the same time, because when you're the only person working a case, then all your ideas are good ideas because there's no one there to tell you it's a bad idea. And we love telling each other when, we like challenging each other to do better. And I think that for the most part, our clients benefit from the dynamic.
Yes, and I don't mind being told that this idea sucks, so it's okay without me.
Wonderful. Well, Shyanne, what pushed you to focus so heavily on communication and client experience along with the legal strategy itself?
It's a great question. When people are navigating this system, one of the main complaints that we'll hear is, I don't know what happened in court. I don't know what's going on with my case. I don't understand this process. And to me, over communication is a tool that we can use to help ease anxiety in a situation that is already stressful enough. There's no reason for there to be mysteries when there don't have to be. So much of the criminal justice process is chaotic in and of itself. And so if we can help make it just a little bit less chaotic for our clients, that's important. And obviously, working as a team, communication is really important in order to collaborate effectively without causing more work and disruptions.
What has working inside a collaborative defense team really taught you about case preparation and courtroom strategy?
Well, life is about point of views, and I have a certain point of view. Cheyenne's obviously younger than I am, and she has a point of view, and Savannah has a different point of view, and our senior partner, Roger May, he has a different point of view. But when you take those points of view and meld it into a common defense strategy, because a jury system, you're going to have people that are 18 years old to people on Social Security. You're going to have different races, different ethnic backgrounds, and you've got to connect and build a defense that resonates to all of them. And I think that's kind of what this process does. I know it's unique in the criminal defense world because mostly it's just single lawyers or single DAs or single public defenders out there. I think this is a cutting edge type thing we developed. How we prepare cases, how we work cases, how we do things. Like, for example, Shyanne likes me to do preliminary hearings because that's what I'm really good at. So I'll do one piece of the case for a case, because that's kind of one of my things I like to do is do preliminary hearings, which is a phase of the case. Shyanne is more subtle than I am, and she might be more effective in negotiating with certain DAs. So it is we kind of plug and play type thing. I don't know if that's the right word or not.
Yeah, it's almost like war strategy in a way. We know our team really well. We know what we're good at. We know who has the relationships that are needed in a case. And because we communicate so well, we sort of deploy each other as necessary to help benefit our client's case.
So you communicate and collaborate well. So how do the three of you challenge each other during case discussions or strategy meetings?
I really don't know if minor children are looking at this, so I don't want to say really too much, but
I think we challenge each other all the time. We had a case last fall that Rob had been the primary point of contact on for almost 2 years while the case was pending. He had a relationship with the client, he had a relationship with the family, and then something happened and the dynamics changed for us in that case. And Savannah and I started coming in and being a bigger part of the team. And then we had the case set for trial and we started trial prepping. And as we started trial prepping, we realized we were going to have very nuanced conversations about consent with a jury. And it's not that Rob can't talk about consent, because he can and he has. It's that as we were working the facts of this particular case, Savannah started to feel like I should be the one talking to a jury about this topic. And she came to us and she essentially said, I think I should first chair this trial, which is pretty bold for a younger attorney on our team. And it was absolutely the right call. Rob and I didn't necessarily agree right off the bat, but eventually we were on board and we got a fantastic result in that case that we would not have gotten if she had not challenged us and asked for some role shifts.
What are some other examples of details or issues that become easier to catch when multiple attorneys are reviewing the same case?
Well, I think one thing that we try to identify right off the bat, all three of us have been to a trial lawyers college, and we like to embrace the danger points of the case. Instead of hiding away from the worst fact of the case, we embrace that and we deal with that right off the bat. Instead of like, they confessed or whatever, or there's an eyewitness. Well, we embrace that, and I think we have to identify the danger point in any case and not run away from it.
I don't think we've ever learned more about our cases than when we bring our entire team into the conference room. Everyone. We turn the phones off, we shut the office down, and we bring everyone into the conference room and we start immersing them in the facts of the case as a jury would receive it. And stepping outside of our lawyer role and into a storyteller role and accepting the feedback from our team of what seems important to them didn't seem important to us. And so we take that feedback and then we work it into our case analysis and our trial strategy.
I just want to share something about our team. So when Shyanne talks about we bring our team into it, we bring in the paralegals. We bring in our office manager who's been years as a paralegal. We bring in our law clerks who are every summer we bring in law students that are in middle law school to have them come in, so we get new blood in, people in their 20s, and we bring in everybody in the office, even the person that answers the phone.
That was actually going to be my next question. When Shyanne said everyone, I'm like, everyone? That's
Everyone.
from our client intake person to our senior paralegals to our office manager, who's really a paralegal too, to the law clerks. Like right now, we have three young brains from Belmont Law School that are working here this summer.
Well, hey, that would be fascinating. I'm available. Just fly me down.
Come on in Nashville.
Excellent. Love to do that. All right. Well, how do the different attorney personalities or communication styles become useful with the different clients and also the different courtroom situations, different judges? How does that all work together?
I think that touches on that deployment piece of knowing who works well where. So, for example, we might do an intake for a case in a different county that Savannah's got really great relationships in, and we don't. So we might tell the client, you've met with us. We know you want to hire our team. Just know Savannah's probably going to be the one going to court for you. And here's why she's going to go to court for you. And that doesn't mean that we're not still working this case as a team. It just means that we think this is the best decision for your case. Same thing with Rob and same thing with me. It's really us coming together as a team and deciding who is the best attorney for this particular client or this particular case or this judge or this DA. And, you know, we do make some jokes in the office about our personalities and how those show up. Rob is like the punch you in the throat first, ask questions later kind of criminal defense lawyer. How would you describe me, Rob?
Well, I've always described Cheyenne as a stiletto wrapped in velvet.
I think that's his way of saying I've got more like assassin skills.
Yes.
And
don't turn around, she'll stick a knife in your back.
All right. And Savannah, Savannah is really well-rounded, probably because she has been with us since law school as an intern and grew with us and has been mentored under both of us. And so she's got this beautiful capability of tapping into Rob's style while also strategizing with me when that's appropriate too. She's very well-rounded.
Yeah, and I'll just share this. I met Savannah after her first year of law school, and a friend of mine's a lawyer introduced us, and so we hired her as an intern, and she's been here at the office after her first year of law school, and now she's been practicing law for, I don't even know how, she seems like she's been practicing law 20 years, but she hadn't.
No.
Excellent. Well, Rob, can you share a moment where a discussion between the three of you changed the direction of a case or led to a strategy that you might not have reached all on your own?
We have tried several cases where we've admitted that our client killed somebody. And the first time that we did it, the first time I did it with Cheyenne, we were in Williamson County, which is just south of here, and we basically told the jury all through the trial that our client killed somebody, and he was charged with first-degree murder. After the case proved, the DA amended the charge to second-degree murder, and then the jury came back with a verdict of shooting into a habitation resulting in death. So somebody was looking at 51 years in prison is now home.
Well, and a big piece of that puzzle, Rob, is that moment where there was a witness and a co-defendant that was charged and had never really told his part of the story. He had accepted a plea deal really early on and was in custody, and no one expected him to come to the trial. No one expected him, if he did show up, to talk at the trial, and he did show up. And Rob and I had to decide in the middle of trial what we were going to do with this witness. And Rob stood up and said, Judge, can we have a brief recess to talk about this with our client? And we all went back into the back where they have the little holding cell. And we had to have a discussion of, do we ask any questions or not? And Rob had his opinion and I had my opinion. And the client was kind of listening to us argue back and forth back there. And I know when we talk about this, sometimes you say that if you and I hadn't had that fight sort of back there in that holding
I
cell,
don't-
we
I
might
don't-
have changed it.
I don't think it was a fight. It was just it was a serious discussion.
Yes.
But that goes back to the collaborative part. We had a chance that at least the judge was it was a judge that in fact I had worked with I was a lawyer with his dad, so I kind of feel like I had some relationship. I had some skin in the game that he would give us a little break to take that recess to recess.
Yeah.
So.
And we made the right call, which
We made
was
the right call.
crazy. We decided not to ask the witness any more questions because we didn't want the state to be able to adjust anything. And if we had asked questions, the state gets to stand up and go again, basically.
Mm-hmm.
But since we said no more questions, then the witness was done.
And in his testimony, even though we try to send an investigator out there, we try to do everything that you're supposed to do, refused to speak with us, and he told our trial story himself.
It was a beautiful moment.
Wow, phenomenal. Well, as we wrap up today's episode, what do people often misunderstand about what a strong criminal defense team is actually doing behind the scenes before a case ever reaches the courtroom?
I think that a lot of clients expect us to be very serious. And a lot of our trial prep is kind of strange, if I'm being honest. We do a lot of trial lawyers college methods. One of our favorites is to do a role reversal. So if clients were in here watching us prep for a trial, they would probably be very confused. Usually we are bringing someone in from our team and we're saying, okay, sit in this chair. When you sit in this chair, you are now becoming John. And John is charged with a Class A felony. He's facing so many years in prison. And these are the facts that led up to this moment in time that his whole life's going to be defined by. And we start warming them up to feelings.
Mm-hmm.
Because what we know is that facts don't really matter when it comes to trial work and juries. What matters is how our jury feels about the facts. We are all making decisions every day based on feelings, not necessarily the facts alone. And most of our trial prep is focused on the feeling of a case. What is the emotional truth of this case? And if we can identify that, we are going in the right direction. It's not always us sitting here with highlighters and pens going through mounds of paper.
Or reading the law.
Yeah.
Well,
And we do read the jury instructions and try to craft the case to fit the jury instructions.
I think you've made a very strong case for the benefits of having a criminal defense team. And that is it for today's episode of the May McKinney Podcast. If you'd like to learn more about Rob McKinney, Shyanne Riddle, Savannah Edmonds, and the team at May McKinney PLLC, visit maymckinneylaw.com. Thanks for listening, and be sure to leave a review, and subscribe to the show so you catch every episode. Thank you, Shyanne and Rob.
Thank you.
Bye-bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.